This is Debt Free in 30, where every week we take 30 minutes and get practical advice from industry experts about personal finance and living debt-free. Here's your host, Doug Hoyes.
It's the month of September, students are back in school, and at this time of year, our thoughts turn to student loans. It's a sad reality in Canada that a significant number of students are only able to pay for post-secondary education with the help of student loans. And if you graduate and immediately get a high-paying job, you can pay back your student loan, and all is good. But what happens if you can't find a job that pays you enough to pay your living expenses and pay back your student loan? Then what? Unlike with most other debts, you can't simply go bankrupt to eliminate your student loans because we have a rule in Canada that says that government-guaranteed student loans are only automatically discharged in a bankruptcy or consumer proposal if you have ceased to be a student for over 7 years at the time you file your bankruptcy or consumer proposal. To clarify, it's not 7 years from when you got the loan. It's 7 years from when you ceased to be a student. So that's 7 years from when you graduated or 7 years from when you left school. Let me emphasize another point. When I refer to student loans not being dischargeable in bankruptcy, I'm referring to government-guaranteed student loans, which would include loans made under the Canada Student Loans Act or provincial programs like OSAP. My guest on today's show will make a comment on this a bit later. There are big banks that offer student lines of credit, often for professionals like doctors. That's not what we're talking about here. Those bank loans are not government-guaranteed loans, so they are not considered student loans in a bankruptcy, so they are eligible to be discharged just like any other unsecured debt. So, what can you do if you've been out of school for less than 7 years and you have student loans that you're having trouble paying? The first step is to do your research and see if there are any deferral or interest forgiveness programs that you may be eligible for. Obviously, if you have the ability to repay your loans, that's what you should do. Another option, if you have a lot of other debts, is to file a bankruptcy or consumer proposal to deal with your other debts, which may free up enough cash to allow you to service your undischargeable student loans. There is one other option, and it's a very special case. Section 178, sub 1, sub 1.1 of the Bankruptcy and Insolvency Act contains what we licensed insolvency trustees referred to as the hardship provision. And it says that if you go bankrupt and have a student loan and you have ceased to be a student for 5 years or more, you can apply to bankruptcy court to have your student loan discharged. There are two conditions. The bankrupt has acted in good faith, and the bankrupt will continue to experience financial difficulty to such an extent that the bankrupt will be unable to pay the student loan. What does acted in good faith mean? That's a tricky question. The common interpretation is that you have tried to make payments on the loan, but if you have financial hardship, that may not be possible. So, what is hardship? And what is good faith? Those are the first two questions I asked Richard Howell, a bankruptcy lawyer with Clark, Farb, Fixel in Toronto. He was a previous guest on this podcast where he talked about bankruptcy court, where he has many years of experience. So here's an example he gave of a typical student loan hardship situation.
Typically, it may be a single mother, for example, that has no possibility of ever paying the loan and just will never have sufficient income to even make a dent. One of the factors in the Act is whether they've made any payments on the loan, which seems to be, I don't know if a bit silly is too strong, but if they could make payments on the loan, they wouldn't be in court on a hardship application.
Yeah, it's kind of a
oxymoron.
Yeah, it doesn't really make sense. So, okay, so let's say then that I went bankrupt, and at the time I went bankrupt, my student loan was 5 years old. Obviously, if it was more than 7 years old, I don't need to go to court because it's going to be automatically discharged. So there's this 2-year window between 5 years and 7 years when this hardship rule kicks in. And I know when someone comes in to meet with me, I say to them, well, if we're at year number 6 now, you go bankrupt today, your student loan isn't automatically discharged. Why not just wait another year to get past the 7-year mark? But in a lot of cases, no, I've got a bunch of other debts. My wages are about to be garnished. I have to do this now. So we go ahead and file the bankruptcy. And then, okay, you know what? Student loans are a big number. I would like to go to court and see if I can get the student loan either reduced or eliminated. So what would be the process? I guess the starting point would be, well, let's talk to a lawyer who knows how to do this. What would, if someone comes in to see you to talk about whether or not they should make a hardship application, how would the discussion go? What kind of questions would you be asking? What would you want to know?
Well, typically when they phone, if they're going to come in to see me, I'll ask a couple of qualifying questions so we won't waste everybody's time. How much are you making? If you're making $50,000 or $60,000 a year, don't bother coming because you're not going to get the relief. Except, well, I guess there's an exception to everything, but it's going to be highly, highly unlikely. The people that typically come in may have got a degree in computer programming is a good example, and they've been working for the last 12 years as a pizza delivery man because there's no jobs. They've got a couple of kids and a wife, and they can't make ends meet. They're a good candidate. Or as a single mother with a couple of kids and making minimum wage, they're a good candidate.
So the qualifying questions, the first one would be how much are you making? What kind of income are you earning? What would be the second qualifying question you'd be asking?
Well, just the timing on the loans. Do you fit into the 5-year period?
Just to make sure that it qualifies. So if I phone you up and say, hi, Richard, I'm a doctor. I make $200,000 a year. I've got $300,000 worth of student loans because of all the degrees and everything I've got, and it's a lot of money and I can't pay it. You're going to say to me, in terms of a hardship application, I don't have much chance. Is that correct?
Yeah, although apropos, the doctors normally have a loan from a particular bank, which will remain nameless, that is effectively a student loan. It's typically $100,000 or $150,000. The bank in question attempted to characterize the loan as a student loan and try and prevent the bankruptcy applying. The court said nothing doing. That was a credit decision for the bank. It's not the public's money. Get out of here, bank.
And we won't say what the name of the bank is, but you can email me and I'll tell you what their 3 initials are if you want to know more. And so, yes, you're making a key point, and that is we are talking about government-guaranteed student loans. So if you go to the bank and get a student line of credit, which is what this particular one was called, then no, that doesn't go under these rules. That's just like getting a Visa card. It's a loan that the bank granted to you on the basis that they figure, well, once you're a doctor, you'll be able to pay it back. So the bank then could not go back to court and say, oh, yeah, this falls under the same student loan rules. So that's, again, why you're asking these 2 qualifying questions then. So
exactly, but let's be careful not to mix a student line of credit guaranteed by Her Majesty with the bank's student line of credit that's not guaranteed.
Gotcha. So I gave the example of OSAP earlier. Obviously, that is a loan directly from a government agency. It is also possible to have a student loan from a regular bank, but if it's guaranteed by the government, then it would fall under the rules we're talking about.
Exactly.
That's the key point then. So okay, the bankrupt phones you up and you have a discussion on the phone and they say, yeah, I have an education, but I've not been able to get a job in my field. Maybe, I'm a computer programmer, but I know a bunch of languages that they don't use anymore because now everything's all apps on a phone and that's not my area of expertise. So I have not been able to earn considerable income as a result of my education. I've got a family, I've got expenses, I'm a single parent, something like that. And so you say, okay, you're probably someone who would qualify for this process. So then the next step, I assume, is I come in and meet with you in person. And obviously, you're a lawyer. You don't do this for free. There's a fee to be charged. And I think, if someone wants to know what that fee is, well, give you a call, because every situation is going to be different, I assume. Some cases are simple or some cases are more complex. But so they come in to see you. What types of things are you going to want to know what happens next?
Well, I'm going to want whatever bankruptcy documents they've got. I'm likely going to have to go to the bankruptcy office and have the file brought in from Cooksville, where they store them, so that I can see everything in the file. The court's going to want everything in the file when we go in any event. I'm going to want to see their tax information for the last few years, returns, notices of assessment, and I'm going to want a statement of income and expense on a monthly basis showing where the shortfall is and that they are actually suffering hardship.
And then from there, you prepare a bunch of paperwork, I guess. And
it's a reasonably simple affidavit. It covers the bases, and then we put the affidavit in what's called a motion record. We serve the trustee and any opposing creditors. And of course, Her Majesty. It probably in both capacities, if they've got a federal loan and a provincial loan. Finding where you serve Her Majesty is always a little bit of a challenge. We think we've got it nailed at the moment, but times change.
Oh, I know. It's always difficult for us too, and it's to who's got carriage of this, because obviously the loan happened many years ago, and so it may be a different address, different department, whatever. So you prepare all this paperwork, send it out to the student loans people, the trustee, any other creditors that may be interested in the matter, and then it's going to take a period of time before the actual court appearance happens, right? I mean, it's
well, you have to serve with 10 days notice from the time you mail it. It has to be at least 10 days prior to court. The practicalities are the Ontario student loans are, last time I did one of these, are situated in Thunder Bay, and typically they get the mail. They look at it at some stage of the game, probably late, and the day before the hearing you get a call from the student loan lawyers in Toronto who say, we need an adjournment. And of course you give it to them, so you get kicked another couple of weeks. But it does mean 2 attendances at court and a little more messing around.
Yeah, and with Toronto court, it's not like a fast food place where you can just go in and get an appointment. Things are scheduled in advance. It takes time to get there, right?
Well, it's reasonable. We can get a motion date, for example, maybe 3 to 4 weeks out.
And obviously that it will depend on the time of year. I mean, over the Christmas break, it'll take a little longer. In the summer, perhaps, if there's vacations and whatnot. But generally, it can be done reasonably quickly, is what you're saying. So then, on the appointed day, you go to court. You would have the bankrupt with you, I assume?
Not as a rule. I sort of like to have them around in case there's questions, but it's not strictly necessary.
Okay. And so, I mean, I guess if it was me and this was a, big deal, I'd want to be there too, just in case the judge wants to, okay, so, why aren't you working or whatever? Obviously, you've got this all in your motion material and your affidavit and everything, but I guess as a backstop, it's nice to have them there. And so you then, at the appointed time, appear in court, you present your arguments. Obviously, a lot of it's in writing already. And what is the typical response of the student loans people? Because obviously they're the only ones who are going to object to this. No one else really is interested. I mean, as a trustee on the case, I don't really have an opinion one way or the other. I'd obviously like the bankrupt to get a break and everything, but the court really doesn't care what I think in this particular case. It's not really up to me. What typically are the student loans people doing? In other words, are they very often showing up in court and banging on the table and trying to argue the motion, or is it more likely that they'll say, yeah, we understand this probably is a hardship case, and they don't argue it?
I think it's fair to say they're typically atypical.
Okay, so there is no rhyme or, well, there's no obvious thing that's going to happen.
No, the spectrum is if it's a meritorious, a righteous application, they'll look at it and say, yeah, this person can't pay. We're not fighting this. They'll send you a letter saying Her Majesty does not oppose. In
which case, you go to court and you stand up and say, I got a letter saying Her Majesty doesn't oppose, and it's pretty much a done deal at that point, I would think.
Yes, except Her Majesty can be of two minds, of course. Her Majesty Ontario can have a different opinion than Her Majesty Ottawa.
Gotcha. So the feds may object, the provincial may not, in which case then the court has a decision to make.
Yeah, pretty much. Or you end up with the counsel in court for the objector, and you make a deal before court.
So explain to me making a deal before court then. So the court hearing is, I don't know, it's at 10 o'clock in the morning, it's at 2 o'clock in the afternoon, whatever it is, and you all know who's on the docket beforehand. And so is it the kind of thing like literally on the courthouse steps, you pull the person aside and say, look, here's what I'm going for, what do you think? Is that how it is, or is it done on the phone in advance? What typically would happen?
Well, it depends. I know the counsel for I know the counsel for the province, who's normally the same one, and I can phone her ahead of time, not too far ahead of time because they've just delivered the file to her 15 minutes before the hearing. But subject to that, we can usually kind of come to an agreement beforehand. With the feds, if they're coming down, the lawyer from Justice gets the file. Well, if it's a 10 o'clock hearing, normally at 9:30 for the first time to look at it. That's a bit cynical, but also true.
Yeah. Well, I've certainly been in court where in exactly the situation you're describing, and the judge, the registrar, the master says to the opposing creditor's lawyer, okay, what do you want to do? Well, I mean, last week we had a case that was very similar to this, and it was a lot more money, and no one was here. And they say, well, I don't know. I don't assign the cases to myself. I just got the file, like you say, yesterday or 15 minutes ago. So in that scenario, then you're going to try to get them on the phone in advance. But if that's not possible, then like literally just before the hearing, then you kind of pull them aside and see what can be done? Yeah,
you make your deal if you can, and if not, tough it out. I haven't toughed out many. One of the ones that I remember is it was before Registrar Nettie, as he then was, and my guy was saying that he couldn't get a job and yada yada, and that he was driving a taxi, and the registrar said, "Let me see the driver's license." So he handed him up the driver's license, and Registrar Nettie knew such things, and he said to me, your client has a commercial long-distance trucker's license here. Get out of here, effectively.
Yeah, so he can get a job making good money, so that's what he should do.
Precisely.
So is it fair to say that in most cases that you've been involved with, because you've, in effect, I don't want to use the word pre-screen, but you've asked questions beforehand, and so you know that the chances of success are reasonably good before you take on the case, that in most cases the court, in your experience, is amenable to this type of hardship application?
Yes, although technically the court has to either wipe the loan out or not. They can't make a deal and say pay half or pay some percentage of the loan.
So it's almost like arbitration in baseball. Well, I say this, you say that, they got to pick one.
Yeah. Yes, but that being said, there have been occasions on which something's been worked out, and I'm not going to give you the particulars.
No. So, and I think the kind of message there is ultimately the court can do what the court wants to do. I mean, that's why there's a court.
Well, no, it's normally done at the let's make a deal level.
I see. And the court either doesn't object to it or blesses it or whatever.
Yeah, if counsel are happy, the court
is happy, yeah. So I guess the message there then is that if you are, going to have a lawyer going to court for a hardship application, it's good to have someone with some experience, and the ideal scenario is work something out in advance with the opposing creditor, if there is one, so that you can go to court and get the deal done. That's generally the better option.
Exactly, and just an aside, as far as lawyers and costs are concerned, my old mentor once said, if you want nice fresh oats, you have to pay the price. If you're satisfied with oats that have already been through the horse, it's a lot cheaper.
It's a lot cheaper. So, yeah, and I guess this is kind of the trick in a hardship application, that the whole point of going to court because I can't pay my student loan is because I don't have the income to do it. And so, do I have the money to hire a lawyer to go and do this? I assume that in most cases, obviously you're going to get something up front if you're going to be showing up in court and everything, but is it fairly typical that you're going to put the debtor on some kind of payment plan if they can't pay for it all up front?
Yeah, it comes with the territory. Something's got to be worked out. It depends on what the client's got, but normally something can be worked out.
Gotcha. And so that's obviously the answer then. Sit down with the lawyer up front, find out what kind of makes sense, and go from there. Excellent. Well, I think that's a good way to end it. So in simple terms, this is a provision of the Act that's there, but as you've said, it's not a very common thing. It only applies to people who have a student loan, they've gone bankrupt, and it's between 5 and 7 years on the clock, which is obviously a limited number of people. Most people are going to wait till after the 7 years. If you could get through 5 years, you can probably get through 7. But for a certain number of people, this is a viable option.
Yeah, for the other people that can't pay the loan, no hope, but they're not going to get the hardship relief. The only other possibility is a second bankruptcy or consumer proposal. It seems kind of sad that the student loan comes to that at the end of the road.
So you would complete your first bankruptcy, which maybe is completed in year 5 or 6 after you've left school, and then it might be that after year 7, then at that point maybe the only debt you've still got is the student loans, and at that point then it's either a bankruptcy or a consumer proposal to deal with it.
Yes, and if there is the possibility, depending on the amount of the loan, that student loans will come in and ask that there be a condition of your discharge that you pay a chunk of the loan. It's remote, but I haven't actually seen it done to defeat a student loan.
But it could happen. I guess that's kind of the message in a bankruptcy, that any creditor has the ability to object to your bankruptcy ending. That's just how the process works.
Yeah, exactly.
Excellent. Well, I think that's a good way to end it. Thank you very much, Richard. That was our discussion about student loan hardship applications. Thanks very much.
My pleasure.
That was my conversation with Richard Howell about student loans and the hardship provisions. And I agree with his comment that this situation is kind of sad. When I went to university, over 30 years ago, it was possible to get a summer job where you could earn enough to cover your tuition and books. If your parents helped out with living costs, or if you got a part-time job while you were in school, you could easily graduate with no student loans. Today, it is virtually impossible to find a summer job that pays enough to cover your education costs. So if you don't get help from parents or scholarships and grants, you have no choice but to get a student loan. If you can't find a good job when you leave school, student loans become a big financial burden. I know that over 15% of people who file a bankruptcy or consumer proposal with my firm, Hoyes Michaelis, owe money on student loans at the time they file, and they owe around $14,000 on student loans when they file. That's a big number. I've advocated for more fair student loan rules for many years, and I'll keep doing so, but for now, if you have student loans you can't pay, you do have options. As I said at the start of the podcast, if you have a lot of other debts, it may make sense to file a consumer proposal or bankruptcy to deal with those debts, so even if your student loan is too new to be dischargeable, dealing with the other debts may free up enough cash to allow you to service the student loan. As Richard Howell said on the podcast, if you have no choice but to file now, it is possible to file again after you reach the 7-year mark. And, as we discussed today, a hardship application may be an option after 5 years. What's the best option? Every case is different, so your best option is to talk to a licensed insolvency trustee, the only debt professionals licensed by the federal government, and by law, there are no upfront fees. That's our show for today. Full details on student loans and the student loan hardship rules, and a full transcript of today's show can be found at hoyes.com. That's HOYES.com. Until next week, I'm Doug Hoyes. Thanks for listening. That was Debt Free in 30.